I'm going to take up the matter of Butler versus Butler. All right, Mr. Butler has filed a motion to alter or amend the judgment in this case. And Mr. Butler, this is your motion, so I'll be glad to hear you.
Yes, sir.
Come to the podium.
Yes, sir. It's hard to remember. I'm currently incarcerated right now and trying to remember everything since I've had no time to really prepare since this. I've also filed a motion for mistrial, and is that part of this too? Or...
I have a motion to alter or amend, and I then have a.
Sorry.
So I'm giving you an opportunity to address all of the issues that you have raised in your motion to alter or amend. Do you not have a copy of it?
I'm not with me, no, sir, because I'm incarcerated right now due to being targeted.
Let me tell you what you said in your motion. Says that you're filing this motion pro se pursuant to rules of civil procedure 59.04 to alter or amend the final judgment in the following basis. You allege the final hearing was held in the matter on July 14th, 2025 and July 15th, 2025. The court's judgment is based on erroneous findings of fact and a fundamental failure of due process, which constitutes a manifest injustice. And do you want to address that issue and what it is that you're saying occurred that
Yeah, the illegal ex parte meeting that happened during the trial that happened, and then also I think it was $800 a month I was supposed to pay in child support, and that was based on her income. And I do remember you specifically saying that the child support should not be based on her income due to me. Like I was laid off from my job, and I wasn't looking for a job because I am, and I've never made as much money as she has.
Well, I want to address that second statement you made. Paragraph 3 of your motion states the court engaged in improper ex parte communication. During respondent's cross-examination of the petitioner on July 14, 2025, the presiding judge, the petitioner, and the petitioner's attorney exited the courtroom and held a private meeting in the judge's chambers. The respondent was excluded from this meeting, which violated his fundamental right to due process in the Tennessee Code of Judicial Conduct, Rule 2.9.
Yes, sir, that did happen.
You're alleging that I had a communication with the attorney for the petitioner and the petitioner and about your case?
I'm not exactly sure what happened. I just know that.
Well, you've made an allegation, which I consider to be a very serious allegation.
Sure.
When I'm talking, just wait for me to finish. So I want to know what proof you have that such a meeting took place, because I can tell you it did not. But I want to hear what evidence you have that you would have placed in such a motion.
So the only evidence I have is that when we were here, and I was actually questioning Mrs. Butler, that all of a sudden Miss Margaret got up and then she got up, and I noticed that you three went through that door, and then I was just left standing here. I didn't know what to do, so I went back and I sat where that man in the blue shirt is right there. I went back and sat right there for about 10 minutes. Miss Butler exited that door, and then about 5 minutes after Miss Butler came out, Miss Margaret came out, and then you came out. I don't know what you guys said. I just know that.
So you have no evidence that any such so-called meeting occurred between me and Miss Brady and the petitioner in this case. You're just assuming that such a meeting occurred because we left the courtroom at the same time. Is that correct?
I just don't know what else would have happened. I did file for a mistrial first, and I don't know why that didn't come through. But I do know that I wasn't getting dates while I was filing stuff. So I tried to, did the mistrial first to make things. I don't know if it would make it right better, or I'm just trying to do the best I can, Your Honor. I lost my son. I was doing everything right. Like, the courts asked me to take a drug test. I passed it. I didn't get my son. I lost my son on false allegations of drug use, and did everything the courts asked me to do. I still didn't get my son back. I lost everything, Your Honor. I lost literally everything. And I've had the Cheatham County Police, they've targeted me and I've got evidence of that. And it's just, I mean, look at me. I mean,
Paragraph 4, you allege that the petitioner provided false testimony under oath regarding allegations of domestic violence, which the court relied upon in its ruling. You vehemently deny the allegation that you jammed your thumbs into the petitioner's eyes or punched her. Basically, you're saying that I relied upon false testimony, but I heard both sides of that testimony. Well, I heard her testimony, and I think you were pending criminal charges at the time, correct?
yes, sir.
Okay. The paragraph 5, the court's judgment relies on a pattern of false allegations. Prior to the final hearing, the petitioner filed an ex parte motion to suspend your parenting time based on claims of drug use and unsafe home. Those claims were investigated by the Department of Children's Services and were proven false. Furthermore, you passed a court-acknowledged 10-panel hair follicle drug test. Anything you want to add to that? I'm considering your motion, so I'm giving you an opportunity to
Yes, sir.
provide me with any kind of proof regarding your allegations.
There was also, there's the allegations that I was homeless, and then they came and inspected my house as well. And did a home visit, and she saw I lived in a beautiful home. I was very stable, and after that, Judge Turnbow, I didn't get to get back in front of him because he went. They go. I guess y'all guys alternate. So I filed another motion, and I was running late to court that day due to my car issue, and I've since filed a motion for that. And but I called as quickly as I could, and the lady said that your case had already been heard and they're not going to do anything. And I was just devastated. I was just like, because I thought that would be the day I get my son back.
All right. Paragraph 6, the allegation of harassment at the ninja class is further evidence of this pattern. The petitioner obtained an order of protection based on claims of harassment and threats. The incident did not occur. Class was held in a small room filled with numerous parents and children. No independent witnesses came forward to support the petitioner's story because it did not happen. Paragraph 7, the petitioner's attorney made false representations to the court. Respondent inadvertently sent a draft email with no threats to attorney Margaret Brady. Attorney Brady then falsely told individuals in the courtroom that the email contained threats and a deliberate attempt to poison the proceeding. So you have filed a motion making these allegations, and today is your day to show to the court the basis for any of those allegations.
Sure. So for the ninja class, it was worded in such a way that I so happenly showed up there, and I feel like the way that things were worded to obtain this no contact order, it was specifically for that and for that only. And just before that incident, or there really was no incident, I was trying to break contact off of Miss Butler because of just how angry she was, and I just wanted to support my son. I've been there since day one supporting my son, and for whatever reason, these people just come out of nowhere and just don't want me in his life. And that's exactly what has happened. And then there was no need for a no contact order. There was no need for that at all. And it was there strategically to violate me 100%. And it was malicious, if you ask me. That's how I feel. I don't have anything with me right now, but and then also my probation was violated at the wrong place at the wrong time, and I'm fighting those charges and more than likely will win. And Miss Brady, before the proceeding of the violation, was telling the courtroom that I have a draft email, and for whatever reason, it was addressed to her, and it was nothing of the sort of threatening. And Miss Brady was talking about it in the courtroom the day before my violation was set to be heard. And my attorney said, "Where's this threatening email?" And I gave it to him. I said, "Here." And there was nothing in there threatening. So for whatever reason, I felt like she was trying to poison the well before it even got started. Because, you know, her sister-in-law does work down there.
All right. Have a seat at the table. Ms. Brady, do you want to respond to the motion to alter or amend the judgment?
Your Honor, we would just say that,
You'll come to the podium, so
Sure.
let's pick up.
sorry. Obviously, we would say there's no ex parte communication with the court. But all the other things that he mentioned in his motion are based on witness testimony, and the court had that opportunity to hear that then and deemed Ms. Butler's version of events to be credible and made a ruling based on that. And we would say that there's no grounds for, to alter or amend this judgment put forth by Mr. Butler today, and we'd ask that that be dismissed and this be considered a final order.
Number one, the court specifically will address the allegation that the court engaged in an improper ex parte communication. Mr. Butler has affirmed on the record that he has no evidence of such a meeting occurring, other than the fact that circumstantially Ms. Butler and her attorney, Ms. Brady, exited the courtroom, and that I exited the courtroom at the same time. That alleged meeting did not occur. There was no ex parte communication between me and Ms. Brady and Ms. Butler. And I specifically find that that allegation was made without any evidence and nothing more than circumstantial belief by Mr. Butler that somehow something was being done inappropriately. So I find that that basis is a false allegation regarding the behavior of this court and that of Mrs. Brady as the attorney for Ms. Butler. In addition to that, all of the other, as Ms. Brady has pointed out, all of the other allegations that he makes are all basically complaints regarding the court's findings at an evidentiary hearing. And the court finds that the testimony that was offered at that hearing was the basis for the court's order that was entered, the final hearing order. And that final hearing order was filed September the 2nd, 2025, which was after his motion to alter or amend. And that hearing order was based upon the facts as were presented in this court at the final hearing, where Mr. Butler was present, given an opportunity to participate, and that as a result of that, no evidence has been brought forward to satisfy the court that there's any basis for an alteration or amendment to the court's prior order. Therefore, his motion to alter or amend the judgment filed August 25th of 2025 is overruled. Then there are some additional motions that have been filed, and I would like to address those motions, and Ms. Brady, unless you need additional time to consider them. He has filed on October the 1st a motion to reconsider and amend the final order as to child support.
Which might not be the top of your list. I filed a motion to dismiss all of the remaining motion and for sanction. And so if we have argument on my motion to dismiss, it might resolve those motions. Might be a way to handle it. Some people won't be able to see.
We'll consider your motion to dismiss, considering and consider that before we take up any of these other motions, because if your motion is valid, then it will not be necessary to consider those additional motions.
Your Honor, so the other motions were not, as you know, set on the docket today, but I wanted to bring them all up before the court today so we could just deal with this all together. So as you can see, I filed a motion to dismiss. He has additionally the motion to reconsider and amend as to child support, an emergency motion to reinstate parenting time and for immediate hearing, a motion for mistrial. There was a motion for personal items. That's already been dismissed by Judge Turnbow because for failure to prosecute. So on these remaining motions, Your Honor, I would say that these are going to fall kind of in the same lump as the motion to alter or amend. They're all based upon problems that Mr. Butler has with testimony that the court considered that he had an opportunity to cross-examine and participate in that hearing. And we would ask that all of those be dismissed. And furthermore, Your Honor, we've also asked for sanctions pursuant to Rule 11.02. And specifically, Ms. Butler is asking that she be reimbursed for her attorney's fees to defend this motion today. As we know, there's been a history of harassment and stalking and domestic assault. And now that Mr. Butler is unable to do that out on the street, he's using this court to continue this harassment because he's dissatisfied with the court's ruling. And he has had no basis to for these motions. And so we would ask that he be responsible for attorney's fees today. Additionally, though this was very late filed, and I'll acknowledge that, I filed a motion to relocate, and also we're having a problem selling the house. I understand if Mr. Butler doesn't want to deal with that today, he has that right. But you had asked that if we can't get the house sold at list price, that we need to come back and talk to you about that. And they've had one showing the whole time that it's been on the market with no movement. And we're asking that if the court will hear that today, that we be allowed to accept the reasonable recommendation of Amanda Bell, who is the realtor, and just try to get this house sold. But I understand if that needs to be reset.
When you say I had asked you to come back and talk to me, you were talking about having come back to court on that issue.
Yes, Your Honor. So in our final hearing or final decree, you had said if she's not able to sell it at list price, that we needed to get permission from the court to reduce that price so that there was a basis for it. And if you need to hear from Ms. Butler, we can do that to describe
you
that.
just filed it yesterday,
Yes.
so I'm not going to require Mr. Butler to have a hearing on that particular issue because of the fact that he's entitled to 5 days notice prior to that. We can set it later in this month for a hearing, but
Okay.
it would not have to be, it would not be fair to him to have a hearing today with a motion filed yesterday.
I understand.
Mr. Butler, did you raise your hand? Do you have something you wish to say?
Yes, sir. The house is listed way too high. It's listed at like almost
I'm up to
400,000.
the podium.
She has the house listed way too high. It's at 400,000. It's not worth that much. I understand that the market value has fluctuated these last few years, but it was nowhere close to that. And then also with the motion for emergency custody was because I satisfied everything the court needed me to do. But right now I'm incarcerated right now with no probable cause. So, that's why I can't keep up with everything. And a lot of this is not based on, so I don't know. I've lost everything. I lost my son. I've lost literally everything for nothing. And they just want to take more and more and more and more. I can't even afford a lawyer, but I got to pay for her lawyer fee. And then they got the house marked up way too hot. And then, Your Honor, I just really hope you'll take into consideration that, a lot of this was done and I have been targeted by the Cheatham County Sheriff's Office. They violated my probation the first time based on words. And then, I've got proof of it. I've got proof of it. And a lot of it came from her. And I just really hope you'll take that into consideration, Your Honor. I mean, I've been a good parent. I'm a supportive parent. I've worked our entire marriage. I've worked until I lost my job. And then on top of that, I didn't just sit there. I went out and I made money. It wasn't, a bum. I did what I could for my son. I went from being that dad every day with my son to nothing. And they just took everything out of my life. I'm in jail right now for nothing because they targeted me so she could win 100%.
All right. You have also, and Ms. Brady, I'm going to go ahead and consider these other motions on the record because it's my understanding he's filed an appeal. Is that correct? He's filed a notice of appeal to the Court of Civil Appeals, and therefore I think that all of these motions need to be addressed that he has raised regarding the final hearing. So the next motion that I'm going to take up is an emergency motion to reinstate parenting time for immediate hearing. Mr. Butler, you have filed a motion to reinstate your parenting time.
Yes, sir, I did. That was before I was on private property, and the Cheatham County Sheriff's Office came up and arrested me for being on private property, and now I'm here. And so if I were to win this, I guess I couldn't get it anyway because I'm incarcerated, but so I don't know if maybe when I get out, if you were to give it to me. But Miss Butler's whole goal was to move back to East Tennessee, where she was from. That's why this, the no contact order for no reason came into play. And that's why a lot of this is like the whole targeting thing is like so aggressive, is so that way she can move back to East Tennessee. 5 hours away. I mean, no, not that I'm a bad dad, not that, I'm out partying, I'm out doing drugs, nothing. It's just bull. And they've got me hemmed up. I mean, it's hard when you're a small guy. You got no lawyer. I did have a lawyer. She withdrew from my case because of Margaret Brady. I've got her on tape saying that. She doesn't want to go against Margaret Brady. She's took all my money, so I had no money left, so I had to defend myself, and I still lost fucking everything. I mean, I've lost everything, Your Honor. I'm sorry. I'm not. It's just. I mean, I'm a good dad that's fighting to be with his son, and I just keep getting shot in the foot. It's pretty bad. It's pretty.
Right. Your motion to reinstate parenting time for immediate hearing is going to be denied simply because of the fact that you're incarcerated. I'm not going to reinstate parenting time because you are incarcerated, but the final order in this case provided that upon your release from jail that you would have the right to exercise supervised visitation every other Saturday and Sunday from 9 a.m. to 5 p.m. each day with no overnights. That would be supervised by a third party agreed upon by the parties. That you would be permitted to petition the court for review of your parenting time after your criminal charges were resolved without the necessity of showing a material change of circumstances. I don't know how I could be any more fair with you in the situation that you're in. All of your argument has to do with how unfair you think it is that you're incarcerated. That's not an issue before this court. The fact of the matter is you are incarcerated.
You're right.
And because of that fact, you're not going to have visitation with your minor child or children until you are resolved of that. And this final order that I put down provides a method by which you can have visitation, and you can even have it reviewed after all your criminal matters are resolved to try to reinstate some sort of a normal visitation. So your motion to reinstate and your visitation immediately is denied based upon the fact that there is provision in the order for that to take place. The next motion that you have is a motion for a mistrial, and I will just simply, I don't even need to hear any argument. Your motion for a mistrial is based upon paragraph 1, ex parte communication, July 14th, 2025, during the final hearing in this matter, the presiding judge, Judge Wolf, plaintiff Aaron Butler, and plaintiff's counsel Margaret Brady left the courtroom together and entered into the judge's chambers for approximately 20 minutes. Defendant Robert Butler was not invited nor informed of the content of the discussions and was not given an opportunity to respond. The ex parte communication deprived the defendant of due process. I've already addressed that issue with you. You have affirmed on the record that you have no evidence of any such meeting occurring, that it was all circumstantial because I left through this door to my right, they left through the door to my left, and as a result, during a recess of this court, that you assumed that there was some sort of ex parte communication. I affirm on the record that no such communication took place and no such meeting took place, and that allegation was based upon a false statement by you. Therefore, your motion for a mistrial is denied. All of the rest of this, of your motion for a mistrial, which is not appropriate after the final, you don't file a mistrial motion after the case is concluded. And for that reason, in addition to the fact that I've considered all of the other bases, and there is no basis for a mistrial to be granted after the entry of the final order in this case. The last motion is a motion to reconsider and amend the final order as to child support. And at that point in time, I found that the mother's income was set at $6,000 a month in the final hearing, that your income was imputed even though you were in jail pursuant to the rules of the child support guidelines, simply because of the fact that if you were unemployed, it was due to your own fault. As a result of that, you could have the imputed income that the child support guidelines provide. I applied that to the calculation of child support, and therefore you're not entitled to an amendment as to the calculation of child support. That concludes all of the motions that are set, other than the motion to relocate, which was filed yesterday. I will not consider that until he's been given appropriate notice, an opportunity, and that would be later in the month that we have a chancery day we can set it.
Your Honor, I know that we're not taking up the motion for reducing the price of the home either, but since Mr. Butler seems to be on the same page as that, you think that we could consider that so that we can get that house sold and they can get some funds?
If he's willing to do it, we can. I mean, if he's willing to waive the 5 days notice and have it heard, yes. Mr. Butler, the rules of civil procedure provide that you're entitled to 5 days notice prior to the hearing on a motion that's been filed. They filed their motion to reduce the value of the property and to accept an offer less than the listing price yesterday. So therefore, you have the right to object to that, and I'll have it set later in the month, or you can agree to hear it today, and then we'll put on the proof, let them put on the proof about why they need to accept this offer. Do you understand all that?
I understand it all. I guess it just depends on how much they want to reduce the price. If she wants to work out a deal or something, I might be willing to talk about it for a minute.
Go ahead and have a seat over here, Mr. Butler, and I'm gonna let Ms. Brady talk with you, and we'll come back to you.
I think that we probably should just reset both of those motions so we can get a clean order from the court, because I'm not sure the agreement that we might be able to reach is going to be workable.
Right. What day in the 24th of November?
All right, thank you, Your Honor.
Butler, those remaining motions will be heard by this court on November 24th. Thank you. Phelps versus Phelps. This is an ex parte restraining order, which is required to be heard within 15 days of the issuance. So we will pick that up next.
Yes, Your Honor, if I could, just from a historical standpoint, give some information. Your Honor, I represent Mrs. Phelps, who is now Miss Miles. Parties have 2 minor children. They were divorced back in January of 2024 by agreement. The parenting plan that was adopted at that point in time designated the mother as primary residential parent, and they had a basic equally shared residential schedule, although the mother is 183 days, the father is 182 days. But they did exercise a week-to-week visitation schedule. But in the other section on the parenting plan that's set forth on page 3 of their parenting plan, there's a specific prohibition that the father shall not consume alcohol to excess during his parenting time. I believe the testimony will be that there was an issue with alcohol during the course of the marriage, and that the father had begun after the marriage going to AA and abstaining from consuming intoxicating beverages, and was attending AA. We have some documentation to that effect. So the parties have rocked along for a period of time until June of this year. There's been some indication, my client would say, that alcohol has started to become a problem again. And in June of this year, the testimony is going to show that Mr. Phelps, while he had the party's eldest child, their son, in his possession, that he was arrested, he was pulled over in Robertson County, operating a motor vehicle. He failed the field sobriety test. There was a blood test administered, and he was charged with driving under the influence and endangerment of a child. My client, he never disclosed this information to my client. My client, the testimony will go, found out, as many people do, through a mobile patrol and social media application, that she found this out. She reached out, testimony will be, to try to discuss it with him to see what the situation, and he's refused to discuss it. She came in saying that it had become a problem, came in October, retained me. We topped up a petition to modify the parenting plan and asked that a restraining order be filed. We got that ready about the time when there was some judicial conference things going on. We forwarded it over here, and Judge Turnbow signed the restraining order on the 24th, Friday, the 24th of October. And so at that point in time, the court forwarded me a copy via email. And I notified my client, but it was going to be Mr. Phelps's week to have the children. And so the kids went on because, again, he had no notice and he was not served with the restraining order. And my client did not want to be put in the position of having to deal with that. So he had them the week. We came before the court last week in front of Judge Turnbow. Mr. Phelps had not been served. So he moved it to Your Honor's date today. As I understand, even though it's not back in the record yet, that Mr. Phelps was served on Saturday. And so what we're here is to determine whether the restraining order should be extended. It's his time tomorrow to get the children. So either asking that the restraining order be extended due to the fact that he put the party's eldest child in significant threat of harm by driving under the influence, or in the alternative to put down provisions, Your Honor, that precludes him from consuming alcohol in any way during his residential time, or subjecting the children to any individual consuming alcohol, so that this is protected. I'm going to be asking him when his court date is, when he takes the witness stand, but that was the basis of us seeking this restraining order, Your Honor.
All right.
Your Honor, I'll attempt in no way to educate the court, as the court is well educated beyond my knowledge. But we are aware that in order to receive one of these ex parte restraining orders, there's a word that is involved, and it is in an emergency. These situations occur in an emergency, Your Honor. We would say that the child needs to be kept from the father for an emergency's purpose. Your Honor, in reading the petition, I would like to point out that very conveniently, disingenuously, however we would like to put it, there's no dates that are listed for reading the petition as to when these facts occurred. And so, Your Honor, I would say, yes, there is an attachment to this lengthy document that does state that the arrest occurred on June 22nd. I believe that you will come to find out that mother had knowledge of this as early as June 25th, Your Honor. June 25th. There's no, Your Honor, you will hear of nothing else other than this arrest. You will hear no facts where my client has put this child in, or these children rather, at harm in any way. Your Honor, you will hear that on July 1st, mom okayed parenting time. You will be able to see text messages where she stated that was fine. Your Honor, CPS has been involved. This has been going on for 18 weeks since July 1st, and all of the parenting time has occurred as it should in accordance with the parenting plan. The issue here, Your Honor, is solely one of the emergency. There's a petition to modify the parenting plan. We call them permanent parenting plans. They're anything but permanent. But nonetheless, there's an avenue by which that the mother can now move. She does have a petition to modify the parenting plan. But Your Honor, I would state that you could see now, without having to hear from anyone, this is not an emergency. She's allowed for 9 weeks. There's been 18 weeks. They have week on, week off parenting time. She's allowed for 9 weeks of parenting to occur, Your Honor. She's not afraid of irreparable harm. If she was afraid of irreparable harm, she would have been afraid of it on June 25th. Here we stand now. It's October. I know we heard that there was judicial conference, Your Honor, and some things of that nature. I've drove all over the state to get these emergencies signed. I've gotten in my car and drove and found judges in their living rooms, Your Honor. So signed on October 1st, not filed until October 21st. Event occurred on June 22nd, and mother had knowledge of it on June 25th. Your Honor, there's a petition to modify down, but I would state that I don't know that this ex parte should have been granted, and certainly I'm arguing that there's no fear of irreparable harm. If it was, it would have already existed.
All right, well, we'll reserve that following the hearing. I'll make a ruling. So, Ms. Roberts, you may put on your proof.
Your Honor, I would call Mr. Brian Phelps.
Well, let's come around, please.
You go climb up in the box. Before you sit down, raise your right hand.
Thank you. Have a seat.
Yes.
Your name is Brian Phelps, is that correct?
Yes, ma'am.
And Mr. Phelps, where are you currently residing?
1070 James Circle, Athens City, Tennessee.
And who resides there with you?
My girlfriend, Jennifer Stamps.
Jennifer what?
Stamps,
And how long have you lived there?
October 1st.
October?
October 1st.
Prior to that, you lived with your parents?
Yes, ma'am.
And that's where you exercised your residential time, is that correct?
Yes, ma'am.
You understand that you and your ex were divorced back in January of 2024, correct?
Yes, ma'am. Danny.
Y'all entered an agreement,
Ma'am.
and part of that agreement was you would have a week-to-week schedule with your children, correct?
Yes, ma'am.
And I think you exchange on Fridays. You were also supposed to split and pay half of uncovered medical expenses, schools expenses, extracurricular activities, things such as that. Is that correct?
Yes, ma'am.
And you understand in that provision, in that order that you set forth in your final decree, that you were not to drink to excess with the children. Is that correct?
Yes, ma'am.
And you recall that as a provision of your parenting plan that you signed.
Yes, ma'am.
Did you have an attorney at the time of the introduction of your divorce, or were you pro se? Did you represent yourself, or did you have an attorney?
I was balanced.
You represent, but you had an opportunity to read that and understand you weren't supposed to do that. Is that correct?
Yes, ma'am.
Now, it's not disputed that at the point in time, around the time of the divorce, that part of the problem in your marriage was related to alcohol consumption. Is that correct?
No.
We could maybe get some direction as to the relevance of this hearing. We're here for the ex parte purposes of what this particular order is. I would like to keep it to the DUI and the timeliness by which it was filed therein.
And it's purely foundational, leading to the fact of that he had an alcohol problem and knew better not to drive with the kids. That's,
And
again,
that's,
simply foundational.
that's an issue by which there's him that can be filed by. This is an emergency process, extraordinary. I'd like to keep it to that.
Overruled. I think it goes to the issue of why the petitioner is seeking a restraining order and the circumstances of it. Again, it doesn't, the order as it presently stands does not prohibit the use of alcohol. It just prohibits the excessive use of alcohol. So I'm allowing it not to consider that for any purpose other than to lay a foundation.
So again, there was some issues in y'all's marriage about alcohol use, correct? And in 2024, you actually started going to Alcoholics Anonymous. And you notified your now ex-wife that you were going, and you were working on issues as related to the overconsumption of alcohol, correct? And so that was the reason why that provision was put in there. Is that right?
Yes, ma'am.
There was a basis for it.
Yes.
Okay. And you had made promises and statements that you wouldn't consume to excess or be under the influence when you were with your children,
Yes.
correct? And for the most part, you complied with that, didn't you?
Yes, ma'am.
Here recently, you've started drinking a lot more, haven't you?
No, ma'am. I
Okay.
still drink, but I don't, them kids are good.
Okay.
I mean,
Well, tell me what transpired, if you would, on June 22nd of 2025. You were in Robertson County.
me
You were operating a motor vehicle, is that correct?
Yes, ma'am.
What kind of motor vehicle were you operating?
2008 D71, my truck.
A Chevrolet Silverado pickup truck?
Yes, ma'am.
Brand new,
No, ma'am, 2008.
2008, okay. A 2008 Chevrolet Silverado owned by you,
Yes, ma'am.
and your son was with you.
Yes,
And
ma'am.
what's your son's name?
Bentley,
And how old is Mr. Bentley?
13.
13 years of age. And you and he like to go and do tractor pulling and things like that, don't you?
Yes, ma'am.
And where were you going? What, was it your regular time with Bentley on this?
Yes, ma'am.
Okay, and where, you have a daughter,
Yes, ma'am.
and what is her name?
Shayla,
And how old is Miss Shay?
she's 10.
She's 10.
Yes, ma'am.
And so this was, do you remember the day of the week that you were pulled over?
It was on a Sunday.
A Sunday.
Yes, ma'am.
And do you know what time?
5:30, somewhere in there.
In the afternoon, not in the morning.
Yes, ma'am.
And so where was your daughter?
She was with my girlfriend Jennifer.
Okay, and where had you been that day?
I had been with my son fishing. We went to a creek with a friend.
Okay, and did you post some pictures of those, of that event on your social media page?
I think I did.
Okay,
Yes, ma'am.
and you were drinking? And this may not have been the time. If I could pass to with this, Your Honor.
What is it you're passing?
Photographs, and
You may.
that.
Yes, ma'am.
You identify the photographs.
Yes, ma'am.
You tell me what those photographs would be.
Yes, ma'am.
And
Me having a beer, me drinking. Yes, ma'am.
you sign the picture.
Yes, ma'am.
That's happened. We were in the day before you were arrested.
Yes, ma'am.
Next, we'll mark it as exhibit 1.
What time of the day were those photographs taken?
Oh, 11, 12.
11 or 12
Yes,
earlier in
It
the
was midday early.
midday?
Yes.
And who all was with you?
It was just me and Bentley.
Okay, and then,
In the truck.
and then they were just, where were y'all?
Off, George Boyd Road at a friend's house, Caleb Cantrell's.
Okay. And so y'all were out there with some friends, and you were drinking.
Grilling. Yes, ma'am.
And I think it shows a beer maybe in your hand.
Yes,
Is that
ma'am.
correct? And then did you continue to drink throughout that day?
Yeah, not, when I got in the vehicle, I had.
Let me interrupt you for a moment. Is your DUI case still pending?
Yes, sir. I've not even been to court for that yet. That's November 17th.
I feel it incumbent upon me to advise you of this fact. You, as a criminal defendant, have the right to refuse to answer any question that you think that your answer might tend to incriminate you and give evidence against you that can be used against you in a prosecution for driving under the influence. I don't know anything about your DUI case other than the fact that it allegedly occurred. I'm not telling you anything other than the law provides you. You are presumed to be innocent of the charge. And as a result, you don't have to answer any question if you think your answer might tend to incriminate you. But to do so, you have to invoke your right under the Fifth Amendment of the Constitution to avoid answering it. I'm sure your lawyer's gone over that with you, but I feel like it's incumbent upon me to put it on the record. So, Ms. Roberts, you may continue.
Yes, sir.
And just on the note that the judge was explaining to you about your right to not incriminate yourself, you understand that this is a civil proceeding. You understand there's a criminal proceeding. Criminal proceedings end up putting you in jail.
Yes,
A
ma'am.
civil proceeding, unless you're in contempt of court, is for the judge to put down orders, not necessarily jail somebody. You understand that?
Yes.
But if you invoke your Fifth Amendment privilege in a civil proceeding, then the court can take can assume that the statement that you refuse to answer would incriminate you. You understand what I'm saying?
Yes.
So if I ask you, were you drunk? And you say, I'm going to invoke my Fifth Amendment privilege, the judge can assume you were drunk. Okay, we
Yes.
understand that?
Yes, ma'am.
Okay, good deal. All right, so you were there, you continued to drink throughout the day.
Yes. Not the whole day, but I did after the pictures. Yes, ma'am.
And do you know how many you drank that day?
It was 8 beers altogether.
8 beers. What time did y'all get to the creek?
And it was noonish, it was around that lunchtime, between 11 and 12.
11 and 12, and and that was when you first started drinking?
Yes, ma'am.
And so from then until what time did you leave?
It was 5:30, 5:30.
And then and you got into a car with your child?
Yes, ma'am.
And is it a king cab where you have two seats, or is it just
Extended cab.
okay, so where was Bentley seated?
Beside me, passenger
He was
seat.
in the front seat with you?
Yes, ma'am.
Because he is old enough and he doesn't have to have child restraint or anything
Yes,
like that.
ma'am.
So he was in the front seat with you,
Yes, ma'am.
and he witnessed you in drinking throughout the day.
Yes, ma'am.
I mean, it wasn't anything you were hiding.
No, ma'am.
Okay, and you got in the car, turned on the car and operated the vehicle, correct?
Yes, ma'am.
And you drove that vehicle over public roads?
Yep.
You pulled out from did you park at a friend's house?
No, we took it back to the creek where we all was.
Okay, so whoever owned that property back there, you went to the creek, you got in the car, you drove out of where it was and got onto another road
Yes, ma'am.
that is maintained by the state and county and that other people traverse and drive on, correct?
Yes, ma'am.
And you operated that vehicle with your child in the car with you?
Yes, ma'am.
And shortly after you got on the road, a police officer pulled you over.
Yes, ma'am.
And again, he administered when you got there, when he pulled you over, did you immediately pull over
Yes, ma'am.
and get out of the car? Or did you wait for the officer to come up and get to
Waited until the officer come up together.
okay. And so he came up to your window and asked you if you had been intoxicated, if you were drinking, if you had been drinking.
Yes, ma'am.
And what was your response?
Yes, sir.
And again, that's on a body camera.
Yes, ma'am.
And he asked you to step out of the vehicle. And at that point in time, what transpired?
Went around back and he was an off-duty cop. He was waiting on another officer to get there. He went around back. He performed his test on me.
Okay.
He took me,
So I asked this question, not offered for the truth, but did he tell you why he pulled you over?
he said my truck had come over the lane.
It wasn't it wasn't a busted tail light, or your license wasn't
Not speeding.
done. It was the way you were operating the vehicle is what he alleged.
Yes, ma'am.
And he pulled you over. You got out, went to the back of the car in front of and waited for an officer to get, a on-duty officer to get there, correct?
Yes, ma'am.
Officer arrived,
Yes, ma'am.
and you were asked to do certain field sobriety tests.
Yes, ma'am.
And they indicated to you that you performed poorly on those,
Yes, ma'am.
correct?
Yes, ma'am.
And as a result of that, they placed you under arrest for driving under the influence. And they arrested you and charged you with child endangerment because your minor child was in the vehicle. Is that correct?
Yes, ma'am.
And instead of calling the mother of the child, you called your girlfriend to come pick him up.
Yes, ma'am.
And you never contacted and told your ex-wife that you had been arrested, did you?
Actually, my son called my girlfriend, not their mother.
Okay. So your 13-year-old, you did say 13, right?
Yeah.
13-year-old son witnessed his father being arrested for drinking
Yes, ma'am.
and driving.
Yes, ma'am.
And then he had to call to get somebody to pick him up.
He called my girlfriend Jennifer.
Okay. But you didn't call his mother.
No, ma'am.
And to this day, when she found out about it, she texted you and said, "Hey, what happened?" And you've refused to discuss it with her, haven't you?
No, ma'am. We have text messages to document that was otherwise. She
Okay.
wanted to meet up at my mom's.
Mm-hmm.
It was brought up that she was gonna be at my mom's. I went to my mom's, she didn't show up. It's in the text, like I said, I printed them off. We got
Was this after you got released? How long were you held?
14 hours.
14
I
hours.
went through 2 shift changes. I was supposed to have been in there 4 hours and out.
Mhm.
I was in there 14.
Did they administer a blood test to you?
Yes, ma'am.
Did they take you to a hospital?
Yes.
And have you got the results of those tests?
Yes, ma'am.
And what were those results?
0.19.
0.19.
Yes.
You understand what the legal limit is?
0.08.
Okay, so you were over double the limit, right?
Yes, ma'am.
Okay. And it's true, is it not, that after that transpired, she reached out to you, y'all, maybe again, matter of perspective. Have you ever sat down and explained to her what happened?
No, ma'am.
Has she asked you?
No, ma'am.
But in fact, the truth of the matter is, sir, is even after the arrest and your child witnessed his father, who he's very close to and learns by example,
Yes, ma'am.
you've continued to drink.
Not and drive for my kids.
And I didn't ask if you were
Yes,
driving.
yes,
You have, after you blew 0.19, or excuse me, not blew, your blood alcohol indicated you were 0.19.
yes, ma'am.
You have continued to consume alcohol. Correct?
Yes, ma'am.
Even though you've had a prior history and you haven't been to a treatment program, you just went to AA, is that right?
Correct.
And you drank when your children have been with you.
Yes, when I have been, yes, ma'am.
Although you may not have driven after drinking a lot, but you've driven after you drank. You've had a beer and driven with your kids, haven't you?
No, ma'am.
It's your testimony here today in front of the court under penalty of perjury that after June, when you were arrested, specifically June, sorry, let me flip back over. June 22nd of 2025, it is your testimony here under oath that you have not consumed an alcoholic beverage and driven with your children after consuming, not whether you were intoxicated, just whether you drank a beer or a mixed drink. Because again, some people like to post things on social media, so I'm not trying to pull any punches with you.
Right.
Okay, and you've been over here to the Mexican restaurant, I think it is, and had you a beer sitting in front of you with your kids, and you drove there with the kids, right?
I don't know if I drove or not. I have had an alcoholic beverage and been places.
And driven with your children, haven't you?
No, ma'am, not driven. No, ma'am. And I have been places with them. Jennifer drives, I don't drive.
But she was drinking too.
I had gotten through.
Has she been drinking? Isn't there a beer in front of her too?
She has consumed alcohol before.
Driven with your children?
No, ma'am.
You're sure?
Your Honor, asking.
Just saying.
Yeah. Think it was appropriate, driving and drinking, how many did you say? 8 or 9? I don't want to put words in your mouth.
No, ma'am, it was. Okay.
But you continued the behavior of drinking with your children present.
Yes, ma'am. But it is not.
What kind of example do you think that sets for your kids?
It is not a good one.
Then why are you doing it?
It is something that's being worked on.
How?
I have consuming alcohol.
You're what?
I haven't been consuming alcohol. That's
Well-
something that I've been working on. 14 hours in jail is a long time to sit there and think about it. And
So
going
you're,
on from that, I met Jennifer, and she has made a big impact on that too. My kids are my world. A lot more important than alcohol.
well, I hope so, but you drank this past weekend, didn't you?
Yes, ma'am.
Well, you said you quit drinking alcohol, so when,
No, I haven't, but I've slowed way down.
oh, you just slowed down. All right, thank you, sir.
We'll see you may question the witness.
No, you did, no, he's gonna question you now.
Your
Mr. Phelps,
Yes, sir.
you know what an emergency is?
Yes, sir.
What's an emergency to you?
When my kids are drowning, we automatically jump in and save them. It's something that happens and occurs, and then immediate action is taken.
Does it occur as soon as you have knowledge that they're drowning?
Yes, sir, right then.
Were you pulled over on June 22nd of 2025?
Yes, sir.
Were you then knowledgeable that your ex-wife was knowledgeable of that event within 3 days?
Yes, sir.
You may.
Mr. Phelps, will you please tell the court what you're looking at there?
I'm looking at where Miss Chastity
And who's Miss Chastity for the court?
sent a.
Tell the court who Miss Chastity is, please.
Miss
who-
Chastity is my ex-wife,
Thank you.
the mother of our children.
Thank you.
This is where she has sent out a group message to me, my mother and her mother of my mugshot, my arrest records.
Is there a date on those text messages?
Yes, sir.
What's that date?
June 25th.
And that's 3 days subsequent to your being pulled over, is that correct?
Yes, sir.
And that's, mother has knowledge of what occurred, correct?
Yes, sir.
Okay, Your Honor, if I can make that the next numbered exhibit. What are you looking at there, sir?
Yes, sir. Text messages between me and her mother.
Okay, what's the dates of these messages?
Where they at?
Let me ask you a
This is 3
question.
days.
Do all of these messages pertain to the events that occurred on the 22nd of June?
Yes, sir.
Is it okay to believe that these messages took place after the 22nd of June?
It will stipulate that they were the day, 2 days after she sent the text
Right.
message, I believe.
Stipulation is that they occurred after the date of his arrest.
Are you in a conversation with the mother there?
Yes, sir.
On the last page, if you will, please, is there a July 1st text message?
Yes, sir.
All right, if you'll read to the court your message to the mother and her response.
Just double checking. I will be picking up the kids at 8 a.m. Saturday morning according to our plan. I sent that
That was a message from you to the mother?
from me to the mother.
The mother's
put,
response was?
The kids would like for you to pick them up at 10 a.m. on Saturday instead of 8 a.m. if you're good with it.
Did she mention anything about immediate and irreparable harm?
No, sir.
Did she mention anything about damage that was going to occur to the kids if you were to have them in your possession?
No, sir.
And so the court is well aware, she knew of everything that occurred with you on the 22nd of June, correct?
Yes, sir.
Your Honor, if I can make that the next numbered exhibit.
We'll mark the exhibit 3.
Ms. Phelps, how many times you've been arrested for alcohol consumption?
One.
Okay, so you don't have a prior history of anything, do you?
No, sir.
All right, are you aware of the legal drinking age in the state of Tennessee? Are you currently a licensed member of the state of Tennessee capable of going and purchasing a beverage?
Yes, sir.
Has CPS come to your house regarding this issue?
Yes, sir.
Okay, and how did that go?
It went great.
When you say it went great,
They had their own bedrooms. They talked, they took pictures, they talked to me.
does the mother of the children have knowledge of CPS coming out?
Yes, sir.
Okay. Have you missed any of your parenting time since June 22nd?
No, sir.
You've not missed any of it.
No, sir.
Okay, and mother is allowing all of this to occur, correct?
Yes, sir.
Tell me when you told the mother that you were going to move in with your girlfriend,
It was right before October 1st.
and tell me what October 1st, what that was.
That was the day we moved in.
Okay. I'm gonna pass you another document if I can.
Mhm. It just the,
What are you looking at there, Mr. Phelps?
These are the papers, the ex parte temporary restraining order attached and new advised.
Is that the service packet that you received this past Saturday?
Yes, sir.
I folded a page on there. If you will go to the folded page, please. You'll see a signature by the mother of the children, where she signed a document under oath stating that she feared that your children would be under immediate and irreparable harm if you weren't kept from them on October 1st. She signed that. Do you see that signature?
Yes, sir.
Signed under oath on October 1st?
Yes, sir.
And counsel has already stated, but you have had your children since October 1st, correct?
this can answer.
Yes, sir.
And
On the front of that document, sir, what is there'll be a stamp for the day that it was filed. What's the-
Judge will stipulate that the document speaks for itself. It was filed with the court.
all right, there's a stipulation that the document does speak for itself.
Your Honor, if I can, actually, I'd like to make that exhibit, Your Honor. That's our only copy. I'm gonna need to have a copy of it.
This is your only copy?
Yes, Your Honor.
Well, this is a part of the court record already. Is it really necessary to make it? an
No, sir.
exhibit?
No,
I'll
sir.
hand it back to you then. I've reviewed the documents in the files. so-
And again, I don't
Yeah.
have a problem stipulating that the court can take judicial notice of what's in the court file.
You're residing where now?
1070 James Circle.
In Ashland City?
Yes, sir.
Have the children been to that home?
Yes,
They have rooms in that home?
they got each other on.
Okay. Enjoyed being with you?
Yes, sir.
Objection, assuming facts not in evidence.
That's all the questions I have, Your Honor.
And
Just a few follow-ups, Your Honor. Mr. Phelps, you just testified that Mrs. Down aware of everything that went on when she sent you those text messages that were introduced as Exhibit 2, correct?
Yes, ma'am.
She didn't know, as well as you didn't know, that you had blown double the limit, correct?
At that time, yes, ma'am.
Well, then why did you say she knew everything that went on? She didn't know you were 0.19 to the point of intoxication when you were driving with her child until when? When did she find that out? Do you know?
No, ma'am, I don't.
When did you find it out?
I don't know the exact date. I do know I don't know the exact date, but my district attorney that I have them emailed me a copy.
When?
What the date was?
Late September?
It was September. I'm not sure.
Okay. Again, you went and were arrested. They drew your blood.
Yes, ma'am.
And is anybody representing you on that crime?
Yes, ma'am.
Who is that?
Jeff Walker.
Okay. Mr. Walker over in Springfield, again, don't tell me what he talked about, but you understood, did you know, that they had to send that off to the lab to get tested?
Yes, ma'am.
And then they get the information back.
Yes, ma'am.
And then that becomes part of the public record when they get it back.
Yes, ma'am.
And so you don't know, you didn't know how, again, I use this not as in an offensive matter. You didn't know how drunk you were until the blood test showed it.
Yes, ma'am.
Okay? And nobody did until the blood test showed it.
Yes, ma'am.
And again, do you think there's a difference between being maybe 0.08 just over the limit as being double?
No, ma'am.
You don't, drunk is drunk.
Drunk is drunk.
Okay. And you were drunk.
Yes, ma'am.
Okay. And again, you had previously gone to AA after your divorce. You had started attending AA meetings, correct?
Yes, ma'am.
And then you quit
Yes, ma'am.
and you drank to the point of intoxication with your child
Yes, ma'am.
and you didn't stop. And again, that didn't make you quit drinking, did it?
Any other questions?
No, Your Honor.
Let me ask you this, what's the most important thing in your life?
My two kids.
Pardon?
My two kids.
So are they more important than alcohol is?
No, sir.
They're not?
No, sir. My kids are, oh, yes, my kids are more important. I'm sorry.
I didn't think it was.
My
that.
kids. are more
The answer you wanted
important
to
me.
give.
And.
Well, you understand why I'm asking that, right? Because you're gonna have to make a choice from this point forward as to whether or not you want to drink or whether or not you want to have your children in your life.
Yes, sir.
Now, I can tell you from my own personal and family experience that it can happen. My father was a World War II vet and he was a heavy drinker on the weekends. And it was some of the most miserable experiences of my life growing up and having him drunk.
Yes, sir.
I didn't enjoy it at all, and all the bad memories I had of my childhood were related to him drinking and tearing stuff up and being a drunk. And he quit one day. And he just completely quit cold. He didn't go to AA or anything else, but he quit. He was a man of strong convictions when he did decide to do something. Now, if you have problems in quitting drinking, then, you know, you may want to think about getting some help, because I can tell you, and this is quoting one of our former judges, you got an alcohol problem if alcohol is causing problems in your life, and you have an alcohol problem. Whether you admit it or not is a different matter. But you've just testified under oath enough to get you convicted of driving under the influence. You may not be planning to contest it anyway. But everything after I gave you my little talk, you still testified under oath about everything that's necessary for the state to convict you of driving under the influence. And so get ready, because that's what's going to happen. And unless there's some basis that I'm unaware of, In any event, what I want you to understand is I want you to see your children.
Yes.
And I think as a father that, you know, obviously you want to do that.
More than
But
me.
you're also setting an example, and I've said this to another parent today. You're setting an example for that 13-year-old son. And would you want your 13-year-old son driving a car when he gets to be 16 after he's drank 8 beers during the day and registered a .19?
No, Your Honor.
Because anyone who's a .19 is not just a danger to yourself, you're a danger to others and to the child that's in your car.
Yes.
Yeah. All right. Thank you. Step down.
Yes. Thank you.
Your Honor, that's our proof.
Does, Mr. Phelps, do you have anything else that you want to offer? Well, I don't need any argument in the case. This is a case that was brought on the hearing on an emergency restraining order. I don't find that to be an emergency basis for a suspension of his visitation, but I am ordering I'm going to modify this, and I want you to see your children, but I don't want you drinking when the children are there. And so you have a choice to make. And they're old enough that they can be brought in and they can testify, and hopefully they never have to. But let's just put it down that when he has the children, there will be no alcohol consumed. As we used to say, no alcohol in you or on you. So you don't have alcohol around the house when the kids are there. Just put it out somewhere else. Exercise your visitation. Try to let your children know that you made a mistake and that you're correcting that mistake. I would strongly urge you before the final hearing in this case to enroll in some sort of therapy that's going to help you with your drinking problem, because I think it seems to, from what the proof I've heard, that you need some help, and that's understandable. So there's no shame in that. It's just a question of getting some help for what you need. So let's, and when I say that there's no alcohol, I don't want your girlfriend, if you're living with her, I don't want her drinking around the kids as well. Let's just eliminate alcohol from their life while they're with you and make a positive experience for them. But that's the only change I'll make in this case. So.
Yes, Your Honor. So just so I understand that residential schedule will remain the same, but the father is precluded, restrained, enjoined, and prohibited from consuming, possessing, alcohol either immediately before or during any residential time. The house, there'll be no alcohol in the home where he's residing, and anyone who's living in the home will not drink while the children are there. Is that correct?
That is correct.
Thank you, Your Honor.
All right. Ms. Roberts will draw the order.
I'll draft the order.
Good luck to you, Mr. Phillips. Rebecca Rose Lewis,
Yes, sir.
and you are here today to change the name of your child, the last name of your child to Lewis. Is that correct?
Yes, sir.
Have you understand that the father of the child has had no contact with the child, but do you know where he is? Have you served him with a copy of this request to change the child's name?
I attempted to, and we also put it, I said we attempted to, and my lawyer put it in the paper for a month and nothing. I do have an order of protection against him, but I mean, there was other ways he could have reached out.
That's all right.
We're here on the name change for a minor child.
I was questioning your client and then didn't realize that you were of the record. But my concern is that although the petition sets forth that the father has had no contact with the child, he is listed on the birth certificate.
He is listed on the birth certificate. That's how the child has his surname, but we have no contact with him at all. Is the court going to require us to do publication to him? And
Well, I think that the law would require that you give him notice because he's the only other person in the world that would have any standing to contest this. And while I certainly understand why she would want to change the last name and think that it might be justified if he's having no contact, not supporting the child or whatever, it still boils down to notice is required, I think, by law. So I think you need to either serve him personally or by publication, whichever if you need to do. So
can we go ahead and have my client swear under oath that she has no way of contacting him, and so we can have permission to do the publication?
so raise your right hand. Let's place you under oath.
Please,
Yes.
please say your full name for the court.
You can put your hand down.
Ms. Lewis, you're the mother of this minor child, correct? Do you have any form of way of knowing where the father of this child is?
No.
Okay, have you had any how long has it been since you had any contact with him at all?
February of 23.
So over 2 years, almost 3. So are you asking the court to allow you to do this name change by publication, therefore giving him notice?
Right, I'll order that to be service on the father by publication, and then upon that, we'll reconsider your motion for.
Thank you, Your Honor.
Thank you.